It certainly has. We, in fact, introduced our imaging portal for concealed weapons detection into the marketplace in late August. So it's a very new product, and there's been intense interest.
Interesting. Well, now, coming from an academic background and as a university professor, what type of support have you been able to draw on from the university? And what should a university do to encourage faculty members to commercialize their inventions or technologies?
Well, I had some background in this technology based on my university research area. But to be perfectly honest, the two areas, academic and commercial, very, very quickly diverged. And there wasn't a lot of overlap between the university and the commercial areas. And to address your second question, I think the answer is education. In the university community, we typically think of educating students. But in fact, in intellectual property matters regarding faculty and their research, we have to educate the faculty. We have to make certain that they understand the importance of intellectual property protection, and that they dot all the I's and cross all the T's that are required to obtain intellectual property protection.
Okay. I have other questions for you, but we already have questions coming in from our viewers, and so I think we're going to move right to those questions. We have one coming to us from Mexico, from the Universidad Tecnológica, and I'm going to have to ask them to tell us the correct way to pronounce their location.
Buenos días nuevamente. Hablo de la Universidad Tecnológica de Nezahualcóyotl, de la carrera de procesos de producción.
You mentioned that after a patent of a product is expired, you cannot reinstate it because it then would become a monopoly. What happens with Coca-Cola, for example, which is a long-standing company?
Okay, we have a particular interest here in Coca-Cola as an example. Peter, would you like to talk about that a little bit?
Sure, I can address that question. I think the difference here is that the formula for Coca-Cola is kept as a trade secret. And trade secrets last as long as the secret is kept. They can last forever. They never go into the public domain unless they become unsecret. As opposed to patents. Patents are monopolies for a limited amount of time, and they expire after that limited amount of time and become part of the public domain. So Coca-Cola has been able to keep their formula for their cola product secret for a long, long time, and as long as they manage to keep that secret, nobody can use that formula.
And with lots of interesting speculation about their secret. It makes for fascinating pop culture. I'm sure that the Pepsi espionage team has been out there too. Okay, we have another question from Argentina again. Welcome back, Buenos Aires. Let's hear your question on this half.
I'm an attorney from Buenos Aires, Eduardo Benavides. It is said that the Patent Office of the U.S. doesn't have enough resources to analyze the great amount of applications that they receive every day, every month. Is this really truly this way, and in what way does this affect the fact that whether or not the office has really treated fairly whatever application, if they have treated it fairly and justly, and that it does merit a patent?
Okay, we've got questions here about the U.S. Patent Office. Can they handle the number of applications that they have? Do they treat the applications as they come in fairly? What kind of experience do we know or have with the U.S. Patent Office?
Well, I think that's a question for Peter, because I don't deal with the U.S. Patent Office directly.
That's actually been an area of debate quite a bit, especially in the last 4 or 5 years in the United States. At least for the last 11 years, the United States Patent Office has operated at a profit. They generate profit based on application and issue fees, government fees that are associated with applying for and obtaining a patent. This profit is siphoned off by the United States federal government and used in other programs in other parts of the government. And there's been a huge debate about that very thing because, as you pointed out, there are a tremendous amount of patent applications being filed right now, and the number of patent examiners in the Patent Office hasn't increased proportionally to the number of applications being filed. So subsequently what happens is that the application review process takes longer than it normally should or would. The time between filing a patent application and actually having a patent issue can be as short as 1.5 years, can be as long as 3, sometimes even 4 years. And that's a long time to wait for patent rights. Also, another problem associated with that fact is that patent examiners are given very little time to actually examine an application. I've heard that they're given about 12 to 20 hours depending on their actual technology. And you can imagine that that's not a very long amount of time. In that 12 to 20 hours, the patent examiner has to read and understand a very complicated technical document, the patent application. The examiner has to conduct an independent search for other patents or publications that have been issued that disclose technology that's the same or similar to that disclosed in that patent application. The examiner has to make a determination of whether that patent application discloses anything new, as well as review the application for all the technical requirements, and then issue what's called a first office action, the first communication from the Patent Office. And so what happens, patent examiners are very rushed in order to produce their first correspondence when reviewing a patent application. And I've heard people complain that very often the first communication they get from the Patent Office isn't very detailed or isn't very well thought out. And I think that primarily has to do with the fact that patent examiners aren't given enough time to conduct the review process. It sort of pushes the burden onto the patent applicant to point out to the examiner in response to the first communication from the Patent Office where the applicant actually considers the technology to be new or novel or patentable. And I think it sort of extends the review process and extends the amount of time it takes to actually have a patent issued. So I would agree that the U.S. Patent Office is sort of strained right now for resources. They've made an effort in the last year or two to hire as many new patent examiners as possible, and they've increased their budget for this very purpose. But we're still waiting to see what long-range effect that has on the patent application process.
So the Patent Office is really just another victim of or is facing the challenges of an information explosion. I mean, we've heard all sorts of interesting data about the rate of knowledge growth and the fact that knowledge or information is doubling I've heard every 10 years, every 20 years. Physicists talked about this, Lowell. Do you have are you aware of any of those numbers about the rate of information explosion and the incredibly exciting and interesting and yet challenging times that we're living in?
I don't know what the rate is, but I know it's certainly increasing dramatically.
And I think we all feel it.
Yes.
In the pace of our lives and in the busyness quotient. So it's very interesting. We've got a question now from another part of the world, from the Dominican Republic in Santo Domingo.
Maria Bisonó from Santo Domingo. In the area of copyright, what do you mean when you're talking about documenting the good ideas? And what difference is there between the copyright and the intellectual property statement?
Okay, this is a specific question for Lowell about what does he mean about documenting the good ideas, and then how do you know when you have something that's copyrightable?
Yeah, I'll take the first half of the question and leave the second half for Peter.
Okay.
But in our firm, we require our employees to document their work in a notebook where the pages are not removable. And so in the normal course of their daily work, they write down what they're working on, what experiments they've done, what the results are, what the possible applications are, in a notebook that has numbered pages from 1 to 100. It's a bound notebook sewn together so you can't take pages out or put pages back in. Then each page is signed and dated and then witnessed by another employee. We don't have 100% compliance on this, as you might guess, but we try to do our best. So that's how we try to document intellectual property.
A very efficient and inexpensive way of securing those rights in their early stages.
Exactly.
Very interesting.
And that's very important as well, especially in the United States. The United States is a little unique in the way they structure their patent rights. The United States is what's called first to invent country. In other words, the first person to invent a technology is entitled to the rights in that technology. In many other countries, the patent system is based on a first-to-file system, which means that the first person to file a patent application with the patent office is entitled to rights. What happens in the United States, not all too often, but every once in a while, someone will file a patent application for a certain technology but not be the first person to invent that. And then what ensues is what's called sort of a priority dispute between the person who actually invented the invention first and the person who first filed the patent application. In order to establish that you are the first person to invent a certain technology, very often you rely on these lab notebooks and documentation that's kept during the design and development process. And so in the United States especially, it's very important to document all stages of development of a new invention so that you can prove that you are the first person to actually invent this technology. As far as the second question goes, with respect to copyrights and how can you tell when something is copyrightable, I think the distinction between patents and copyrights, the main distinction that you should keep in mind is that patents cover functional aspects, copyrights cover the creative aspects of something. So it's likely that you can, for example, invent a new sort of table lamp. Maybe it functions in a new way or has a new light bulb. There's technology incorporated in the light bulb that has never been used before. You could actually patent the functional aspects of that light bulb. It's also possible that lamp will have a sort of creative or artistic shape to it. And it's possible to use copyright protection to cover the non-functional but artistic or creative aspects to that lamp. Copyrights generally are thought to apply to things like music, literature, poems, TV programs, movies, videos, that sort of thing. And again, it covers the creative, non-functional aspects of those products.
So the textual representation.
Right.
And it covers the way that it's expressed, not necessarily the idea. Somebody else can say that idea in a different way, and then they can copyright that. But if you've been particularly eloquent in how it is that you've said it, then you get credit for that expression.
That's exactly right.
Yeah. Okay, very interesting. Well, we're back in Mexico again, in Sonora. And we have a question from the Universidad de Sonora.
Sí, un saludo nuevamente desde
Gracias.
la Universidad de Sonora.
Again, greetings from Sonora University.
El derecho a poder
The right to patent something, once it has been published, a certain original product, sometimes it enters very difficult situations or times. For example, the Russian scientists that have just published the discovery to detect or to attack or combat the correspondence that contains anthrax virus. And so these scientists always tried to show their advances and sharing that they publish these. So my question is, these kinds of international agreements like the do they have a certain time, a grace period, so that once these things have been published or given to the public, that the public gets news of the invention, that this can be protected by a patent?
Okay. Our question is about the time or the grace period whereby the person who's expressed the idea, I guess, in a technical journal or in some sort of scientific format. Now, what kind of time frame do they have to get it to patent?
In most countries, once an idea or an invention is disclosed to the public, if a patent application isn't filed, patent rights are lost forever. And there's no way to recreate those rights. The United States is a little different in that they have a one-year grace period, which means that if you publish your invention or make it publicly available, you have 1 year from the first date of this public disclosure in order to file a patent application in the United States. If you do that, a patent can still issue in the United States and you can still secure patent rights in the United States. As Lowell pointed out earlier, there's a decision that companies need to make very early on in the invention process. And the decision involves whether you pursue patent protection for an invention, whether you keep the invention secret, or you publish the invention, make a public disclosure to prevent other people from patenting this invention. And that would be the third choice. If you make a public disclosure, you prevent other people from getting a patent on that invention, but you also prevent yourself from getting a patent on that invention almost everywhere except for the United States, where you have this one-year grace period.
Okay, we have a question from Ciudad de Mexico, Mexico City, from CTM.
Buenos días.
Hablo de la Confederación de Trabajadores
I'm
de
talking
México.
from Mexico. My name is Micaela, and I am a coordinator of this group that is with union leaders in this organization. Thank you for the wonderful presentations, and greetings to all of you. Question is, the patents, rather, of medicines against AIDS, how long can they continue to be protected as a formula belonging to only one owner in a certain country, and how long time does it have to elapse in order to use it widely, taking into account that this is a pandemic thing and that it is expanding to all the different countries?
Thank you for that question. You certainly raise an issue that has been talked about in our press extensively. How long is the patent on the drugs?
Patents on drugs are the same length as patents on any other invention, 20 years from the earliest filing date. Many countries don't allow patents on any kind of drug that has a public health concern associated with it. In the United States, the way that we deal with that is, even though a patent can issue and the patent protection runs for 20 years from the earliest filing date, companies that own these patents often are required to give compulsory licenses, allowing other companies to make the drug and make it available to the public as long as this company pays some pre-negotiated royalty.
Thank you. We have another question from the Dominican Republic, from Santo Domingo, but from the Centro de Decisión y Investigación Institution.
My first question is, what are the sectors that have received most patent applications in the U.S., taking into account biotechnology and drugs and the pharmaceutical area? And also, what protection within the copyright do you need? What's the place of folklore and traditional knowledge in the copyright issue?
Okay. Do we know what sectors have the most patents filed?
I think that the two sectors that have the most patents filed, at least in the last 3 years, are biotechnology and the electronics industry.
Okay. Any other comments on that?
No.
That sounds good to you, huh?
Yes, sounds good to me.
Okay. And we have another question from Santo Domingo, from Seriopex.
Yes. And this is the Center for Promoting Exports. Our question is, what is your position with regard to the compulsory license implementada por quién, perdón?
What is our position with regard to the compulsory license?
Implemented by TRIP.
Implemented by TRIP. Is that a nod of knowledge about what the question's referring to?
Well, sort of. I don't have any particular position. TRIP is just an international trade agreement, and I don't have any particular position on the compulsory license provisions of that agreement or otherwise. I mean, Lowell may as a businessman. No?
No. Okay. I'm betting that our questioner does, and that'll have to be a topic for a more interactive discussion later. We have another question coming to us from Argentina, from Buenos Aires, Argentina.
Sí. La pregunta es,
The question is, what is the margin of action or the role that you have to play in protecting consumers to be able to regulate generators of products and services generated by virtue of the commercial or trade secrets?
So how do we have to protect consumers in this process?
Well,
go ahead, Lowell.
I think intellectual property law in general, and certainly the patent laws and regulations are designed to encourage the development and flow of technology. I'm sure in some cases that doesn't happen, but that's the general, that's the reason why intellectual property law exists.
Okay. Well, we're back in Mexico for another question from the Instituto Politécnico Nacional.
I just want a clarification. The patents do not grant the owner the right to produce something during the period that it's in force. They don't. Neither do they confer that right to the other people. So who produced that? Who produces that?
Who produces that?
Well,
Yeah.
a patent doesn't give you the right to produce something. A patent gives you the right to stop other people from producing something based on that invention. It essentially gives you a monopoly for a defined period of time. And in return for that monopoly, for a defined period of time, the invention then goes into the public domain for use by everyone after the patent expires.
So do people ever take out patents to basically block, a particular
I'm sure they
product
do.
or invention? Or
For example, if you have a competing firm and you study what they have been doing and you see the direction they are going, your firm may take out a patent that prevents them from moving ahead.
from moving in that direction.
Exactly.
So it's sort of an anti-information sharing position in order to protect your competitive advantage.
That's correct.
And then maybe you'd be working on something alongside that would perhaps move your product in that direction. Boy, there's so many interesting questions here with intellectual property that take us in so many different competing directions. We just have a couple of seconds left here. Do either of you have any sort of concluding comments about the questions or the nature of the discussion today? Anything you want to leave with our viewers that they might think about later?
Well, I mean, my only comment is I think that the interest in this program has indicated to me that intellectual property is important to many people, that there are still many questions that need to be answered about it, and there is still an effort that needs to be made to educate the public on intellectual property and harmonization of those rights worldwide.
Okay, I think we're going to leave it with that, and thank you all for your excellent questions, but unfortunately we've run out of time and we'll have to continue this at a future time. We hope that you have enjoyed participating once again in this exciting, multilingual, multinational program. We invite you to participate in our 12th and final video conference of this year's series, which will air on December the 6th, 2001, entitled Excellence, Value, and Quality Performance, New Generation Pillars for Client Satisfaction. For additional information on this year's video conference series, please consult your participants manual, where you will find the dates and specific topics for each program. You may also visit our website, itcgroup.org. On behalf of all of us at the International Training Center, I thank you for your enthusiastic participation and interest in today's program. Gracias, and see you again soon.